If you own your home and you are 65 or older, there is a government rule that can take that home from your family after you are gone, and the people who are supposed to explain it to you have a financial reason not to. By the end of this video, I am going to name a specific legal document that can stop this process entirely, but you have to ask for it by name because almost no one will bring it up on their own. The rule is called the Medicaid 5-year lookback. The name sounds like it is about reviewing your past. It is not. It is about punishing you for things you did in the past that you had no idea were a problem. Here is how it works in plain terms. If you ever need long-term care in a nursing home, and the average cost in this country is now more than $108,000 a year, there is a very good chance you will run out of money. When that happens, you apply for Medicaid to cover the bill. But before Medicaid pays a single dollar, a state official goes back through the last 60 months of your life. Every bank statement, every property record, every transfer you made, the Christmas check you wrote your granddaughter, the money you gave your son for his wedding, the car you signed over to your nephew for $1, helping a grandchild with tuition, forgiving a loan to a family member, charitable donations above a certain threshold depending on your state. Every one of those moves gets flagged. Then the state adds up everything you transferred during those 60 months and divides the total by what they call the regional penalty divisor. In most states, that divisor runs between $10,000 and $12,000. The result of that division is the number of months Medicaid will refuse to pay for your care. During those months, you are expected to pay the nursing home yourself at more than $9,000 a month, even though the whole reason you applied for Medicaid is that you do not have $9,000 a month. That is the trap. You gave the money away, so you cannot pay. But because you gave it away, the state will not pay either. And the nursing home does not care about any of that. They will sue you, and the first thing they come after is your house. Before I go further, I want to be clear that nothing I share here is personal legal advice. Every situation is different, and the rules vary by state. What I am doing is walking you through how this system actually works so you can have a much more informed conversation with the right kind of professional. Now, here is something that trips people up constantly. The federal gift tax exclusion, which sits at $19,000 per person per year right now, has absolutely nothing to do with Medicaid. That is an IRS rule. Medicaid is a completely separate system with its own rule book, and Medicaid does not care what the IRS allows. A gift that is perfectly legal under federal tax law can still trigger a full Medicaid penalty. Most older Americans assume their gifts are safe because they stayed under the IRS limit. They are not safe. These are two different systems, and confusing them is one of the most expensive mistakes a family can make. Now, let me walk through what this means if you are married, because this is where things get even harder. If your spouse enters a nursing home, you might think the law protects the healthy spouse who stays home. There is a protection. It is called the Community Spouse Resource Allowance, and in 2026, it is set at $157,920. That is the maximum in countable assets the at-home spouse gets to keep. Everything above that has to be spent down before Medicaid contributes a single cent. $157,000 sounds like a cushion until you think about what it actually has to cover. Property taxes, home repairs, Medicare premiums, food, fuel, prescriptions, and emergencies for the rest of the healthy spouse's life, which could easily be 20 more years. Do that math, and $157,920 works out to roughly $657 a month. That is what the state's formula expects you to live on, while your husband or wife is in a facility billing more than $9,000 a month. And that is where most people stop worrying, because at least the house is safe. The house is the one thing they cannot touch. That is what nearly every older American believes, and it is wrong. The house is exempt while you are alive and living in it. Medicaid will not force you to sell it to qualify. But the moment the Medicaid recipient passes away, a separate federal program activates. It is called the Medicaid Estate Recovery Program. Federal law requires every state to pursue repayment of care costs from the estate of any Medicaid recipient who was 55 or older when benefits were paid. The target is almost always the house. The state files a claim against the estate. Your heirs are told to either pay the full bill, which often runs into hundreds of thousands of dollars, or sell the home and hand over the proceeds. The average estate recovery claim in this country now exceeds $74,000. In some states, it exceeds $200,000, and it is not optional. The federal government requires the state to pursue it. The home your parents promised the grandchildren ends up belonging to the state where they lived. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an older law called filial responsibility. These laws say that adult children can be held personally responsible for their parents' unpaid nursing home bills. For decades, these laws sat on the shelf unused. Then, in 2012, a Pennsylvania appeals court ruled that a nursing home could collect $93,000 from an adult son for his mother's care, and lawsuits started multiplying. So, the danger is not just the state taking the house. It is the state taking the house and then the nursing home coming after your children for whatever is left. Let me show you what this looks like in real life. Take a woman I will call Ruth, 78 years old, widowed, living in Ohio. Over 4 years, Ruth transferred $45,000 to her daughter. Birthday money, Christmas checks, a little help when the car needed major repairs, nothing she thought twice about. She entered a nursing home in month 47 of that 4-year window. The state divided her $45,000 by Ohio's penalty divisor of $7,463 and found that she was ineligible for Medicaid coverage for 6 months. The nursing home billed $9,200 a month for those 6 months. Total bill, $55,200. Ruth did not have it. The county placed a lien on her home. She passed away 8 months later. The state then filed an estate recovery claim for an additional $140,000 in care costs. Ruth's daughter received a letter telling her the home she grew up in would be sold by court order. Ruth did nothing wrong. The system just does not tell you this until it is already too late. Here is a good moment to pause, because what I have covered so far is only part of the picture. Before this video is done, I am going to walk you through the specific document that can block all of this, the one most attorneys will not bring up unless you say its name out loud and exactly what steps to take this week. If you want a deeper look at everything we cover here, I put together the Hank Sullivan Retirement Protection Pack. You can reach it through the link in the description below or by pointing your phone camera at the QR code showing on screen right now. It goes further than a single video can. But stay with me, because the next piece, how one legal structure resets the clock entirely, is the part that changes everything. Social Security rules, Medicare guidelines, and Medicaid policies shift every single year, and nobody from the government is going to call you to explain what the latest change means for your household. That is what this channel is here for. Subscribe and turn on the notification bell so you never miss an update that could cost you. Now, when attorneys talk about softening the damage when time is already short, some use what they call the half-a-loaf approach. If you or your spouse already need care, you give away half of what you have left and use the other half to pay for care during the penalty period that the gift triggers. It saves something. It is better than losing everything, but it requires exact timing, a specialist to execute it, and it must happen before you apply for Medicaid, not after. Once the application is in, that strategy is gone. The people who lose everything are almost never the ones who planned. They are the ones who were never told that planning was even an option. They sat in the hospital room, signed a power of attorney, and started writing checks to the nursing home, not knowing that one phone call to the right attorney 2 years earlier could have protected the house, the savings, and the inheritance. That document I mentioned at the start is called a Medicaid Asset Protection Trust. In 5 specific states, Florida, Texas, Michigan, West Virginia, and Vermont, there is also something called a ladybird deed, which accomplishes a similar goal specifically for your home. Here is how a Medicaid Asset Protection Trust works. It is an irrevocable trust. You transfer your home, your savings, and your investments into it. Technically, you no longer own those assets, the trust does, but you can still live in the house. You can still receive income from the investments. You just cannot pull the principal back out. Once 5 years pass from the date the trust is funded, Medicaid cannot count those assets. The Lookback cannot reach them. The estate recovery program cannot reach them. The house is protected. The savings are protected. Everything inside the trust passes directly to your heirs, without probate, without a recovery claim, and without the state's involvement. The reason most attorneys do not bring this up is straightforward. Setting up a Medicaid Asset Protection Trust correctly costs between $4,000 and $12,000. A basic will cost around $200. A senior walks in asking for a will, the attorney sells them a will, and the conversation about long-term care planning never happens. So you need to walk in already knowing what to ask for. You have to say those words out loud. Medicaid Asset Protection Trust. Ask whether you qualify. And you need to do it at least 60 months before you need any level of care, because the 5-year clock does not start until the trust is actually funded. Not when you decide to plan, not when you make the appointment, but the day the assets are transferred in. Let's walk through this together step by step in terms of what you can do this week. First, pull together every bank statement from the last 60 months and go through them looking for any transfer over $500 to a family member. Write them all down. You need to understand your exposure before you talk to anyone. Second, find an attorney who is certified specifically in elder law. The credential is called CELA Certified Elder Law Attorney. A general state attorney is not enough. You need someone whose practice is built entirely around Medicaid planning. Third, say the words Medicaid Asset Protection Trust by name in that meeting and ask whether you qualify. If you live in Florida, Texas, Michigan, West Virginia, or Vermont, also ask about a ladybird deed for your home specifically. Fourth, get the trust funded as soon as possible. Every day you wait is a day added to the end of that 5-year window. Fifth, make sure every adult child in your family understands what you just learned here. Because this rule does not only affect you, it affects everything you plan to leave behind. The 5-year clock starts the day the trust is funded, not the day you watch this video, not the day you called the attorney, the day the assets actually move, which means the most expensive day of your life could be the day after the day you should have started. Here is the bottom line. Your home is not automatically safe just because you are still living in it. The gifts you gave your family in good faith are not automatically forgiven. And the rules protecting your healthy spouse are not as generous as the government makes them sound. But none of this is inevitable. The people who protect their families are the ones who learn how the system actually works before they need it. Now, I want to ask you something directly, and I hope you will drop your answer in the comments because I read every single one. Did you know before today that the Medicaid Lookback could count regular family gifts, birthday money, holiday checks, help with a car repair as a penalty against you? Tell me below. And if you have a parent, a sibling, or a friend who owns their home and has no idea this rule exists, please share this video with them right now. The cost of not knowing is too high.